So today we are going to discuss what are the opportunities that are there for criminal lawyers in the area of intellectual property. So the idea of today's webinar is that mostly students are unaware that as a criminal litigator, you can work in the area of criminal intellectual property as well. So first of all, a brief introduction from about myself. I am Yash Vijayvargiya. I have graduated from NUJS in 2016. I was a legal counsel for Bharat Petroleum for 2 years. After that, I have my own independent practice before Madhya Pradesh High Court and Trial Court. Now, what are the things that we are going to be discussing in today's webinar? Guys, can you see the screen? Please reply yes on the chat if you can. Hi, Srichan. Perfect. So yeah, now what are the things that we are going to be discussing today? First is what are the different opportunities available for criminal lawyers in the field of intellectual property. So if you're somebody who is specializing in criminal practice, what kind of work do you get in the realm of intellectual property? Second, I'll be telling you about the criminal proceedings that happen under Trademarks Act. We'll go through the important provisions that are there and things that you need to keep in mind. After that, we will talk about the criminal proceedings under the Copyrights Act. I'll also be drawing a comparison between Trademarks Act and Copyrights Act, because as you must be aware, trademarks and copyrights, they also exist simultaneously. So there are a lot of cases in which you will have the option whether to go under the Trademarks Act or Copyrights Act. And I'll be explaining why going under the latter is a better idea. And then we will also talk about the relevant provisions in the Indian Penal Code. Whenever you're filing a complaint or FIR under Trademarks or Copyrights Act, you will always conjoin it with provisions in Indian Penal Code. So we will have a brief look at what are the important provisions that you will have. Then we will talk about what are the things you need to keep in mind when you're drafting a criminal complaint under the Trademarks or Copyrights Act. All right. So let's start. Before this, let's start now. So what are the different opportunities available for criminal lawyers in the field of intellectual property? So any idea? What do you think, if you are a criminal lawyer, what kind of work you can do in the realm of intellectual property? Let's try to be interactive. So the first and foremost thing, very obvious, is that as a criminal lawyer, you will get a lot of clients who will come to you for drafting a criminal complaint. So these would be cases where their goods have been counterfeited. Say, for instance, if they are manufacturing a certain kind of good and a third party copies their design and shape, trademark, or take some content out of their website or book, then the best way to stop them immediately is drafting a criminal complaint. So that would be your major thing, that you will be drafting a complaint, keeping in mind ingredients of various sections that are involved. And trust me, this is not a simple task, because you need to have a very good understanding of what are the different sections that are involved while drafting a complaint. Okay. Now the second thing that would be quashing of FIR registered under the Trademarks Act and Copyrights Act. So as you know, the offenses under Trademarks Act and Copyrights Act are cognizable offenses. So there would be a lot of time where FIR would be registered against your client for offenses under Trademarks and Copyrights Act. So you will be approaching High Court for quashing of FIR under 482. Then third would be representing the accused in these cases. So the third type of cases that obviously would flow from these two is that you'd be representing, if your client has been named as accused, then you'd be representing them and defending them in the trial in these cases. So these are the three major kind of work that you get in intellectual property cases. Now we will immediately jump into what are the penal provisions under the Trademarks Act? So, first and foremost, Section 103 and 104 of the Trademarks Act. So, what does Section 103 says? Section 103 of Trademarks Act gives you penalty for applying false trademark, falsification of trademark, trade description, trade dress, etc. So, as per this section, if somebody has copied a trademark that belongs to another person, falsifying or even deceptively similar trademark, because you have to understand under trademark the comparison is that the trademarks need not to be exact replica of each other. You do not have to keep them side by side. This is a settled judicial precedent that if for a third person, if they think that this is the same product as the earlier product, it has to be from a reasonable eye. So if there is a confusion that is leading there, and most importantly, if they are product in the same category, then they will be covered under Section 103. And what is then Section 104 prescribes the penalty for selling goods or providing services to which false trademark or false trade description is applied. So this is a charging provision with relation to 103, while 103 defines what are the conditions in which a falsification of trademark will come. 104 prescribes the penalty in relation to it. Now, most importantly, the most important section here is Section 111. So why do you file a complaint under 103 or 104? When do you go for criminal prosecution in comparison to civil proceedings in trademark? So generally there are 2 or 3 cases in which client will approach you. The first would be when somebody has directly copied their good verbatim and is selling in the market. Now, as a business owner, what is my first concern? Yes, I will try to get an injunction from civil court, but my second and most important concern would be not to get the damages, but to stop them immediately. And especially if I do not know where the manufacturer is and who is manufacturing it. For instance, you must have seen a lot of times that when you go to market, there are a lot of these cheap variants of companies which will be selling sports shoes with a different name probably. Now you and I can identify that this is not an original good, but for a third person it is very difficult to identify, especially somebody who is living in a rural area or a smaller city. So how, as a brand owner who has manufacturing and presence in different cities, how will I solve this situation? So what I will do in this situation is criminal complaint is a very good way, because what happens is you immediately give rights to the police to go and seize the goods. I will explain these provisions in detail towards the later half. So forfeiture of goods. Section 111 of the Trademarks Act says that when a person is convicted of an offense under Section 103 or 104 or Section 105 on proof that he acted without intent to defraud, or under Section 104 on proof of the matter specified in the clause. So basically, under this section, what happens is this section gives, irrespective of your intent, if there's a falsified trademark that has been applied to your good, your goods will be liable to be seized. Now, Section 114. This is most important. If the person committing an offense under an act is a company, the company as well as every person in charge of and responsible to the company for the conduct of its business at the time of the commission of the offense shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. So as per this section, if a company is involved in the offense, it's not just the directors, but every employee who is part of the company and who has knowledge and who has a malified intent will be part and parcel of the crime being committed, that is falsification of trademark. Now Section 115 clause 4. This is again very relevant, because what are you filing criminal complaint for? the idea is not to just get the person who is doing the act arrested, but also to ensure that all the infringing copies that are there of your product, cheaper variant probably, similar variant probably, they should be seized immediately and taken off the market so that your reputation and your goodwill is not harmed. So section 115 clause 4 says any police officer who is not below the rank of deputy superintendent of police or equivalent may, if he is satisfied that any of the offences related to in subsection 3 is being or is likely to be committed, search and seize without warrant the goods, die, machine, plate, other instruments or things involved in committing the offence wherever found, and all the articles so seized shall as soon as practicable be produced before the judicial magistrate of the first class or metropolitan magistrate as the case may be. Now read very carefully, provided that the police officer, before making any search and seizure, shall obtain the opinion of the registrar on facts involved in the offence related to trademark and shall abide by the opinions obtained. So now there's a catch when it comes to proceeding under Trademarks Act. The catch is that after filing the complaint, before acting, the police officer will have to take opinion of the registrar of the trademark, whether the trademark that you have complained against, the falsification, whether they are similar or not. So in this case, the police officers cannot act on their own. They will have to compulsorily take an opinion from the registrar of trademarks. And this is where most of the complications come, because this is a slow process. Taking opinion of the registrar and takes a lot of time. So in a way, what happens here is then this becomes very similar to civil proceedings. So now there are ways, there are turnarounds, and there are different ways in which we bypass this provision. I'll explain that to you later. So yeah, any questions till here, guys? I'll give you 2 minutes. Is everyone able to follow? So what we have discussed right now is what are the penal provisions under the Trademarks Act. So the idea behind trademarks is, can anybody tell me that if I have a bottle of a certain shape, can I have a trademark over its shape? For instance, this is a bottle. So can I have a trademark over its shape? And if somebody is manufacturing a similar bottle, can I act against them under Trademarks Act? No, Sachin, the answer is yes. So you can actually, this is a common misunderstanding that people think that trademark is just about the logo or panel. But if you'll go to the definition of Trademarks Act, so I'll just share, just a second. So basically, trademark includes shape of any good. Mark includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of color or any combination thereof. So always remember that you can. Just a second.